when YouTube starts?
Well, I don't know if it'll be good since I'm driving at the moment.
You'll be like act like welcome everybody, and there's something there. Well, how about I just actually, is Joanna on too?
I'm here. Can you hear
You
me?
want you want to welcome everyone, and we'll just start, and then you can pass it on to Stephen.
Sure. I'm still trying to get set up. I think I got sound and video, but two different threads. Welcome. We're excited to have your talk today. It looks like I see Ido and Stephen and Curling. But welcome to Tech School. Thank you to all the participants for being here. Did you all cover the how to do questions and all that?
No, I haven't. You can cover.
So for all of you that are listening, if you have questions, just type them in the chat. And Ido, just so you know, we're all monitoring the chat, so you don't have to keep track of your conversation and slides and all that. At the same time, we'll read out the questions to you if that's helpful.
Okay.
That's all I have, but I'm happy to have everyone here today, and we can go ahead and get started.
Great. Thanks, Steve. Thanks, Stephen, even for coordinating out. Steve's always doing all the IT and stuff for us and coordinating things. But thanks, Stephen, for always doing that. Actually, I always thank him on that. I'll leave it to Stephen. He can do the last minute housekeeping.
Awesome. Yeah, just a few housekeeping things before we get started. If you're watching on YouTube, or if you're watching this recorded on YouTube, feel free to like, comment, subscribe. All the interactions we get with videos like this, whether it be a like, on a video, whether it be a comment, you're sharing your thoughts, asking a question, something like that, helps these videos reach more people. So you could help push this video out to an entrepreneur or somebody who really needs to hear a few things that were mentioned in the video today. So if you have a chance to do that, it's a great way to give back. But I will hand it on over to Ido.
Okay, thank you, Stephen. Let me see if I can share my screen here.
Sure.
Let me know if you get the screen up.
Yeah, actually,
you see it?
Yeah, it's great. It's like on brand with like focus, has the black and all. That's great.
I'm a marketing genius. What can I say? All right, let me set this up so I could talk to you guys. So hi, everyone. My name is Ido Tuchman, and I'm very grateful for the opportunity to talk to you guys about monetizing intellectual property. So intellectual property, or IP, is property that you can't touch. Patents, trademarks, copyrights, those are all considered IP. And IP is very important for startups because it's often the most valuable asset they have. So as you probably know, I'm a lawyer, and before we begin, I have to give you the standard lawyer disclaimer. So you're about to hear a lawyer speak about the law. This presentation may cause drowsiness. So Sam, this is especially important for you. Please don't operate a vehicle or other heavy equipment during the presentation. You're gonna have to like pull over.
That's crucial.
Yes, this isn't legal advice, and I am not your lawyer because of this presentation. Okay, we got that out of the way. So let's begin by talking about Bob. Business Bob came to my office asking for help with a software agreement for his startup. Business Bob had this idea of bringing more traffic to websites by data mining message boards. But Business Bob wasn't a programmer, so he hired developer Dan to write the code. Developer Dan can be a little grumpy, but developer Dan was a really good coder, and his code worked well, and Business Bob was able to help clients get more web traffic to their websites. So it was a great little startup. In fact, Business Bob's product, which he named Bullfrog, worked so well that Licensed Larry was interested in using the software for his business. Business Bob was very excited about this opportunity, and he wasn't sure what to do. He needed help creating an agreement for the software. See, selling software is a little different than selling a physical product. That's because you're not actually selling the software. You're selling the underlying rights associated with the software. So when you go to a store and you buy shoes, you don't have to click a user agreement every time you go to the checkout stand. That's because you're not buying the intellectual property rights. But with software, that's different. We've all experienced buying software and clicking that whole big user agreement that nobody ever reads. And in that agreement is all the language that has to do with what you can and can't do with the IP for the software. So, like I said, the underlying rights is the intellectual property of the software. And as I mentioned, it usually includes patents, trademarks, copyrights, and sometimes even trade secrets. So to understand what rights Business Bob had to sell, we have to first examine each type of intellectual property that's involved. So when we think about patents, we usually think about utility patents. Utility patents protect the inventions. They protect like the function of an invention. So a utility patent protects or gives the owner the right to exclusively make, use, and sell the invention. So here's a utility patent showing a drone pulling a water skier. If you wanted to sell a product covered by this patent, you would have to get the patent owner's permission first. By the way, this patent is owned by Amazon. Yeah, Amazon has a patent with a drone pulling a water skier. So utility patents protect useful ideas. In the US, a patent application must be filed within 1 year of the invention's first public use, sale, or offer for sale. So if you offered your invention for sale this year on January 1st, 2020, for example, a patent application must be filed on or before January 1st, 2001. Otherwise, you lose your rights to get a patent on that invention. A patent application is examined by the US Patent and Trademark Office to determine if it meets their strict legal requirements under patent law. One of those requirements is that the invention must be novel and non-obvious. If a patent is granted, it lasts for 20 years from the date of filing. This is for a utility patent. So Business Bob never pursued a patent application for his software. Filing a patent application can be very expensive. Attorney fees for drafting and filing a patent application can easily exceed $10,000. We have in the chat what qualifies as for sale. So whenever you go and you actually go and market the product, or you're selling or you're offering an investor part of a deal to finance the invention, then that would be a offer for sale. So you don't need to actually exchange money. You just need to offer the invention for sale. So I hope that answers the question. So it can be an expensive process, and Business Bob saw similar solutions while developing his software when he was hiring developer Dan to write the software. So he wasn't sure if he was going to meet that threshold for novel and non-obvious. So ultimately, Business Bob decided that the slim chance of obtaining a patent wasn't worth the legal costs for filing the patent. In any event, by the time Business Bob spoke with me, his software had been in public use for over a year, and so patent protection wasn't even available due to that 1 year bar date. However, Business Bob named his software Bullfrog, so he had a trademark on the software. So a trademark is any word, logo, phrase, or design that identifies the origin of a good or service. A trademark is a brand that distinguishes your goods or services from those of your competitors. So unlike patents, trademark protection can last as long as you keep using that mark as an identifier of the origin of your goods or services. There are many trademarks, like even to this day, that are over 100 years old. Also different from patents, you don't need to file a trademark application with the federal government to receive trademark protection. A trademark protection is automatic in the geographic area where the mark is used. And that was exactly the situation with the bullfrog mark. Business Bob never registered the mark in the US Patent and Trademark Office, so he had trademark protection only in the geographic areas where the mark was being sold. However, if he did file federal registration, then that would give Business Bob legal protection in all 50 states. It's called constructive use. There's also no one-year deadline to file a trademark application. So Business Bob could always potentially go and get a national trademark protection by registering the bullfrog mark at any time with the Patent and Trademark Office. So the amount of trademark protection your mark has depends on how distinctive the mark is. The greater the trademark protection, the easier it'll be to prevent the mark or confusingly similar marks from being used by your competitors. In addition, distinctive marks are easier to register in the trademark office than non-distinctive marks, and distinctive marks will stand out in the marketplace more. Trademarks are usually divided into 5 general categories. Fanciful marks are completely made up words that have no meaning other than to indicate a brand or product. So these marks enjoy the greatest trademark protection because they are absolutely distinctive. So Adidas, which I don't think means anything, is so distinctive that even if they don't make health and beauty products, they would probably be able to successfully stop someone from marketing a deodorant called Adidas. Arbitrary marks are real words that are not related to the product class. Like degree deodorant is an arbitrary mark because it's not well, it is a real word, but the brand relates to measurement, not to health and beauty products. So arbitrary marks are given less protection than fanciful marks, but they're still considered strong marks. So degree could probably stop a competitor from using the degree mark in the health and beauty market, but they would have a much harder time preventing someone from marketing degree sneakers, let's say. Suggestive marks are words that suggest the quality or function of a product. Suggestive marks require thinking to connect the mark with the product. And descriptive marks describe qualities of the product or service. Descriptive marks can't be registered as a trademark unless the public comes to associate that mark with a particular source. Descriptive marks provide relatively little protection among competitors with similar marks. But unfortunately, startups will often reach for descriptive marks when they're branding their product or services. That's because they want customers to quickly understand what they're trying to sell. So they'll try and get they'll try to find a mark that connotates what they're selling very quickly in the minds of their customers. But a trademark choice can end up that kind of trademark choice can end up being harmful in the long run because it'll be harder to distinguish the brand in the marketplace. So there's finally the last category is called generic marks, and these are marks that use a common term for the product or services. And these marks are not given any trademark protection. That's because everyone has the right to use generic words to describe the products that they're selling. So the bullfrog mark, Business Bob's mark, is a strong mark that identifies the product's source of origin in the marketplace. Business Bob's trademark rights protect Bob's business from confusingly similar marks. As long as Business Bob keeps using Bullfrog, the Bullfrog mark to identify the product, the trademark protection can last indefinitely in the geographic area of use. And as mentioned, Business Bob can always get a national trademark protection by federally registering the mark with the US Patent and Trademark Office. Unfortunately for Business Bob, License Larry was not interested in the Bullfrog mark. License Larry was looking to incorporate Bob's software into an existing product with its own branding, and he didn't need Business Bob's trademark. So Business Bob had potentially one more intellectual property asset to offer License Larry, and that was the software's copyright. A copyright is actually a bundle of rights that protect artistic expression from unauthorized copying. For purposes of copyright law, program code is considered artistic expression. A copyright includes the exclusive right to reproduce a work, to prepare derivative works based on that work, to distribute copies of the work. And with few exceptions, anybody who wants to exploit or commercialize a copyrighted work must get the copyright owner's permission first. Copyright law offers weaker software protection than patent law, and that's because someone could create the exact same software and not violate the copyright as long as they didn't copy the original source code. However, copyright protection is a lot easier to get. Like trademarks, copyright protection is automatic. There's certain legal advantages to registering a copyright with the US Copyright Office, but it's a relatively easy process. A copyright lasts for the life of the author plus 75 years. If the author is a business, then the copyright lasts for either 120 years from the date of creation or 95 years from the date of publication, whichever is shorter. Normally, the author of the work is the original owner of the copyright. However, if the work meets like certain legal requirements for a work made for hire, then the employer is considered the author and the original owner. If you recall, in Business Bob's case, the developer Dan was hired to write the software. Developer Dan was not an employee of Business Bob's business. And furthermore, the contract that Business Bob and developer Dan had to write the software didn't address copyright ownership. Therefore, developer Dan was the author and the owner of the copyright, not Business Dan. Luckily for Business Bob, developer Dan was actually very nice, and he agreed to assign the software's copyright to Bob's business. So if developer Dan didn't agree to the assignment, Business Bob would have been in serious trouble because he would have had virtually no intellectual property assets to negotiate with License Larry. And License Larry probably wouldn't want to incorporate that software into his business because License Larry could actually get sued by developer Dan for copyright infringement. So it was a good thing that developer Dan and Business Bob had this good relationship. So after obtaining the copyright assignment from developer Dan, things worked out for Business Bob. License Larry signed the contract to incorporate Bob's software in Larry's product. And Business Bob continued to use the software for his own business while collecting royalties from License Larry. Business Bob and developer Dan worked together on several other projects and are good friends to this day. So here's some important takeaways from Business Bob's journey. First, you have a year to file a patent application from the time you publicly disclose or offer to sell your invention in the US. Some countries, they don't even give you that year grace period. So I would avoid the temptation of using a descriptive mark. So choose a stronger, suggestive, arbitrary, or fanciful mark for your product or service And finally, and I think this is the most important thing to take away, is always pay attention to who the owner of the intellectual property being produced for your startup is. Make sure you get IP assignments from independent contractors and employees, because it's a lot easier to get assignments before you hire someone than after you hire someone. So that's my talk. You can reach me on the email. I'm on LinkedIn, and I'll be happy to answer any questions.
Thank you, Ido. We did have some questions that were going on during your talk. I felt like you had a good flow going, so I would go through. But I was going to trip to you had a question. Did you can unmute yourself and answer that? I mean, post that if Tripty's still on. I think her question was more related to that first one. And it said, what qualifies, quote unquote, for sales, and is an actual transfer of money, or if it's on a wait list order is placed.
So it doesn't have to have any transfer of money once you start negotiating, and just the offer for sale, you don't have to actually consummate a deal to have a offer for sale.
And then we had another one that I think that's real clear, Ido. We had another one saying, what's the kind of geographical region the software or content consumed on the internet get trademarked under?
So it has to be some kind of direct contact. Just having a website, a lot of courts have said that wasn't enough to constitute geographic region. But if you have some kind of like contact form where you start to deal with someone in a certain region, then you're using the mark in that region. So it can get a little tricky, and it can get fact-based. It's, this law was created back when people were selling goods and services before the internet was going on. So the internet has put some of that law in flux, and different courts have interpreted it differently, but you need more than just a website with a general advertising for your product or service.
That's great. That's good. And Vivian, do you want to unmute yourself and ask your two questions?
Oh, for sure. Thank you, Ido. This was really so insightful. So my first question was, is the addressing of IP implied or covered when you use gig sites like Fiverr or Upwork, or does that require, another separate agreement on top of that? And then, how do you identify a good IP attorney?
Okay, so I don't think Fiverr or any of these gig sites address IP ownership. I haven't really used their services, but I don't believe that they do. That you'd have to negotiate that, like as you're negotiating the gig, upload a contract that specifically says, this product or whatever it is that you're like, this website is being assigned to your startup, and have them sign it. It's really important to make sure you have good documentation, because if it ends up being a very important piece of asset and you're looking for investors, sophisticated investors are going to want to look to see that you have that pedigree of ownership for your assets. And then as far as how do you find a good IP attorney, there's a bunch of websites that are out there that rate attorneys. I typically, when I'm recommending an attorney outside my area of expertise, I will call my network of people. So I would rely a lot on your network, and find attorneys that have performed well for people that It's tough. I sympathize because it's hard to know who's a good attorney and who's just a very good marketer. But yeah, that's the best advice I can give you on that.
Thank you. That's awesome.
Curling, I think you're on mute.
Thanks. I appreciate that, Ido. We have a couple more questions too. I know we have some from previous one. I maybe will start putting priority on the chat ones just because I think those are interesting too, Ido. So we'll continue on the chat part. But Nathan, you want to unmute yourself?
Sure. Thanks, Curling, and thanks, Ido, for your time today. My question kind of revolves around any business that works with the more creative IP assets, like say photography or music production. What are the best practices or best resources for making sure those are protected under copyright law?
So registering a copyright is a good way to make sure, document that you're the owner. It's not that hard of a process to do. You could hire an attorney to do it, but I would recommend going on the U.S. Copyright Office's website and looking at their forms and seeing if you could save some money doing it yourself. Having agreements in place before you take on work is always a good idea. There's several websites out there that have these standard forms for photography. There's also a good website. I forgot the name of it, but it's a website for an attorney that's also a photographer, and there's some amazing advice on that blog. I can look for it again. I came across it once or twice doing research, and I can send you that info.
That would be awesome. I appreciate that.
Sure.
That's very helpful.
Brianna, did you were raising your hand too? Did you have an additional question?
No, I didn't. I think it's just kind of stuck from earlier.
That's great.
I have one, Curly.
Sure, Joanna.
So I was just was thinking about trade secrets and wondering like how do you involve a lawyer in it? Like, is a trade secret just a secret that you keep, or is it like is it an actual legal thing that you should involve a lawyer in? Or
yeah, so trade secrets are state dependent. Every state has its own rules about what constitutes a trade secret, but generally it's information that is not publicly known and that has a commercial purpose to, and your business is taking steps to keep it confidential. So think of like a customer list, any kind of know-how that is proprietary would usually constitute a trade secret. And
like an algorithm, could that be a trade secret?
An algorithm could be one. The famous one is the Coke formula, right? Yeah. So any kind of secret ingredients that you have in your product. And usually when we negotiate a license for IP, if the situation requires it, we'll also have some kind of requirement that the trade secrets be transferred or disclosed to one side or one party. Sometimes, if you're selling a business, you'll want to have key people in the business stay on as consultants that will provide the trade secrets or the know-how to a company. So they come into play there, but they're not like a federal thing that you apply for.
Thanks.
Sure.
We have a raised hand from Alex. Alex, you want to unmute yourself? You have a question?
Yeah, can you hear me?
Yes.
Perfect. Hey, Curleen, how are you guys doing?
Good.
Thank you for your time. Just real quick, and I have a question about timing and rights. I think when you get the patent and or trademarks, It's about the right to use the product or the rights to sell and all those kinds of things. So when you're in a startup and one person is developing the product and the company is still under getting funding, and so they haven't really paid for the development, but they have a promise to pay. And then the company doesn't get funded, but the developer continues to keep inventing, and so who has the rights to that invention and or development? And that might be a more personal question and more details, but I'm concerned about timing, ownership, who can file, who has the right to file. And in your example, very similar question, it worked out because they were buddies and they were friends, but things change when things change. So anyway, that's kind of the setup question, is the timing and the rights and who has the rights.
Yeah, that's a great question. So it's similar to copyrights, where you have the author is the default owner of the copyright, or with patents, it's the inventor that is the default owner of a patent application and patent if it's issued issued patent. So what makes an inventor? It's the person who conceives the idea. It's not necessarily the person who executes the idea, if that makes sense. So if Business Bob came up with this concept of, we can do marketing by mining message boards, and just explicitly said, like, here, developer Dan, here's what I want you to do. And developer Dan just kind of went along and did what Bob told him to do, then developer Dan wouldn't be considered an inventor. It would just be Business Bob. But if the developer Bob said, oh, this algorithm would be efficient, and if we incorporate this to the invention, you would get a lot better results, and it's something that would be unexpected. So at that case, then both Business Bob and developer Dan would both be co-inventors of the patent. And not only that, they would both be able to exploit the patent separately from each other.
Okay.
So that's important, because if you have a startup and you have, like, let's say 2 co-founders and they never had an agreement, then if things go south and the one of the founders leaves the company, then they could still go and license the invention to others and actually compete against the startup. So it's important that everybody assigns the invention rights to the company.
Okay.
All right. So that's the timing aspect of it, is to get this done all ahead of time, to make sure that you have all your ducks in a row. Unlike Business Bob, if things go wrong and things don't work out well, then it could cause a lot of legal problems. And it may ultimately make the startup unsuccessful.
Okay. And just a follow-up question, who can be on the patent? Because sometimes you see multiple people on it.
Yeah.
And some of those people might be maybe board members or is it people that actually are inventing? I mean, what's the rules?
So you can only put the inventors on the patent for the inventors. You'll see issued patents, they'll have a list of inventors and the owner of the patent. But you can't put down somebody who, under the inventors, you can't put down somebody that just wants an ego boost and be listed on the patent. That would be considered a fraud on the patent office and could jeopardize the validity of a patent. You don't want to do that. So, if the boss comes in and says, like, hey, yeah, I want to be on this patent, and doesn't contribute any inventive concepts to the patent, they could actually jeopardize the validity of that patent if it ever gets litigated.
Okay. And so that patent then gets transferred to the company. If the company hasn't really invented anything, how does the company get on
Yeah. So you'll usually in a company will have the inventors assign their rights to the company. So sometimes you'll when you start a job, they'll give you a whole bunch of documents. One of those is an assignment of your IP rights that you developed during employment to the company. And if you're hiring a contractor, then you'd want to have that assignment ahead of time. So it's really up to the company, but it makes a lot of sense to do all that, all those assignments to ensure you have ownership of the intellectual property ahead of time.
Okay, thank you.
Good. Yeah, great questions, Alex. We had one more question from Vivian, and then I'll pass over to Stephen. Vivian, you can unmute yourself. It was a good question on continuity.
Hi again. My question is, when you update your trademark and or your code, like, does it automatically transfer the IP, or do you have to file again? Like, just being in the startup phase, if I make a change to my logo or something like that, how does that impact?
Yeah, if you're doing a redesign of your logo, you'd want to file a new trademark. A trademark filing in the federal trademark and patent and trademark office only protects the mark that you applied for. But at the same time, if you're using a new logo, and remember, you have that automatic geographic protection in the areas that you're using it. So just by changing the logo and using it in some particular geographic areas, you're getting protection. But if you wanted to get that national protection, then you would need to go and file a new patent, a trademark application. And not only that, like if you're going into a new market, then you would have to file an amendment to your trademark to get because when you file a trademark, you have to say what goods and services you're using your trademark for. So anytime you add a new classification of goods or services, you have to file a new trademark application for that.
That was a great answer. We have two more questions coming up. Stephen, how are you doing on time? Would you want to answer some of these questions on chat or some of your the questions you had from the other cohort?
Oh, it's fine. We can answer the ones in the chat, and then we can pose a few from the other cohort too.
Okay, sounds good. Sam, Professor Clark, if you want to unmute yourself, you can. You had a good question.
Oh, I just had a question because you were talking about this a little bit, and I think what you probably already answered it. But with an employee, if you're paying an employee, that doesn't automatically mean that the company has a right to the invention. They have to actually make an agreement between the employee and the company. Is that correct?
Yeah, there is a legal doctrine called shop rights, and so if you're using company assets like their computer, their equipment, then a company could be entitled to some protection from the patent, but it's not a really good way to go about doing things. That you'd want to get the employee's assignment either ahead of time or afterwards, and a lot of companies will also have an assignment to things that are related to the company. They'll have an agreement ahead of time where even if it's not something that the company is selling right now, but if it's something very related, then they'll also look for an assignment of that. And some companies try to push the envelope a little bit on that, and courts have had to push back against those companies, saying like, no, you can't, you don't own your employees' brains. Like there are limits to what they can come up with on their own. But once you start using company assets, then a company is in much stronger position to claim that that should be their IP.
I think that was a great answer. Professor Clark said thanks. He did cut off. We have one more from Nathan offhand. Nathan, you want to unmute yourself?
Sure. Yeah. Thank you for fielding a bunch of questions on here. This is all extremely helpful to get this detail from you. I'm just wondering, when you file a trademark, I saw on the other page with the Adidas logo and all the other logos, those are very simple, I guess, images of those logos. But if you were gonna say on a given garment or on a given product, you wanted to show the logo in a different color or have part of the logo in a different color, do you have to file a separate trademark for every single iteration of the logo you do? Or do you just need that generic look of it?
Yeah, that's a good question. So you can get different types of trademark. When you apply for a trademark, you can apply just for the words, and it doesn't matter what style font you're using or what color. So Adidas has a trademark on just the word Adidas, and anytime somebody uses it in any font, any color, just by using that word, they have a cause of action against that infringing use. You can also file a trademark application on a stylized form of the word, and you can specify whether there's a particular color that's being used, and you can also just file a trademark on the logo itself, just the picture. And again, you can specify whether that picture has a particular color or not, and you can file a trademark on a certain shape of a container. So the iconic Coca-Cola bottle has a trademark for that. So there's different level of protection. The broadest protection is just the word itself. But then you can specify particular colors, particular designs for your mark, and get protection on those. So if you, like, for example, if you filed for a logo without specifying a particular color, then that trademark would protect any color.
That makes a lot of sense. Thank you.
That was a great question, actually, Nathan. Stephen, I know we have a couple of questions from the cohort. I think we can take a couple of those, and then we'll go and do kind of like a little wrap up on speed networking.
Sure. Yeah. A few of the questions from the cohort actually got answered, but I'll pose a few that were outstanding. So the first one, Ido, how does IP transfer work when some of the IP is from your university? So we have startups in our ecosystem that may have students or a group of students, maybe working in coordination with a project or with a class, do some work for them. So how does IP transfer work in that situation?
So again, just like Business Bob's situation, you have to first look at the ownership issue. Who owns the IP? Is it the university? Is it the individual inventor? And those are very fact-specific questions. So was there a faculty of the university involved, and does that faculty member have some kind of assignment to the university? And so if that faculty was, let's say, an inventor, and they have to assign their rights to the university, then the university would have rights. Was the student being paid by the university for the research? There you have more of an employee-employer type of arrangement. Was there supervision by a professor? Was there special equipment used during the research? So all those things have to be considered, and to figure out like who owns this thing. And then if the university has ownership, then they'll usually have some kind of technology transfer office where they will work with the startup to usually they'll want like some revenue from the invention. So there you'd have to have some kind of licensing agreement with the university, and figure out, how that technology is going to be used in the startup and what the interests of the university are.
Awesome. Thank you, Ido. So another question we had from our cohort, is it possible to unintentionally infringe on a copyright? And if so, how can this be avoided?
Oh yeah, you could definitely unintentionally infringe on a copyright. This is really important for startups. Somebody mentioned like one of those Fiverr websites where you have somebody develop a website for you. Well, you can bet if you're paying like $35 for a website, they're not going out and hiring a model and creating original work for you. They're probably using stock images that they found on the web, and you have to be really important that either they have acquired rights to that image or that your startup gets those rights. So anytime you're getting work done for you, you should make sure there's even a Google image search where you can look at the images that let's say a contractor provided you for your website. Google those images and make sure that those are images that you have rights to use, or you go on Getty Images and get a license. You want to do that ahead of time. They're not that expensive, but if they catch you infringing, then it's going to be very expensive. So you want to search for those images. I had a client that was a sculptor, and she found out that a company was using an image of her sculpture on a product, and whether they did it intentionally or not, it didn't matter. This was like the image was not in the background or anything. This is up front on the product. So we sent a cease and desist letter to the company, and we made sure that artist got payment for the art that was displayed on the product. So you want to make sure that you have rights to any copyrighted work that you're going to use on your product, on your literature, on your marketing, all ahead of time.
That's great, Ido. I like that. And Miguel, are you still on? You want to unmute yourself? I know some of our groups are doing senior experience. I know that was one interesting thing. But did you want to add that comment about senior experience, Miguel?
Sure. Thanks, Curling. Any projects done through our university are the intellectual property is owned by the sponsor. So there is a sponsor application that is reviewed. We own zero of it. We do not own the fruits of that labor. It is owned in totality by the sponsor of the project. And we have written code. We have written MVPs throughout the university, and we do not own that code. That code is owned by the sponsor of the project.
That's a great point. And that's something that the sponsor has to do ahead of time. And you can imagine if that's the sponsor's intent, if they didn't have that worked out ahead of time with the university and students, they would have a really hard time finding all those students and whoever's involved and getting an assignment after the fact.
Yeah.
So,
in our case, just to explain how we operate, so scope of work is defined by the sponsor. I review it along with my business partner, Roger Hertzler, and we review both the scope of work, the deliverable timeframes, the specifics of outcomes, and the student is responsible for submitting to us their MVP or whatever creative they may have developed in order for them to get a grade, in order to pass the class, in order for them to move on and or graduate. So we have a very specified learning experience, which is why the university is involved at all. It's not, we don't do what we do to monetize it. We do what we do to be of service.
Right. Yeah. I mean, it's very important to get that firsthand experience for the student.
Yeah. Thank you.
Thanks, Miguel.
You bet.
Stephen, I know you always had that one key question you always ask everyone. You want to answer that, and then we'll start the whole speed networking.
Sure, yeah. So there's a question we bookend a lot of these sessions with, especially when we talk to founders. So Ido, we know that in addition to being an IP attorney, you're also a startup founder, and you've told us a little bit about your startup before. Imagine you had a chance to talk to your younger self before, kind of at the early stages of your journey as a founder. What are one or two tips you would give your past self, given what you know now?
That's a good question. So for those of you who don't know, I do have a project, a startup that I'm very passionate about. The website is busylabs.org, and what we're doing is creating 3D printable robotic kits that schools can print out using a 3D printer. So they invest a little bit of money for a 3D printer in their school, and then they can print out these open source 3D models and use off-the-shelf electronic components to provide their students with very accessible STEM type of learning kits. And I'm not a marketer, and I'm really bad at it. And I remember when I was working with Focus, and you had some great advisors there. One of them was Michael Norton. You remember him, Curling?
Yeah, yes,
Yeah.
definitely.
He gave me some really good advice, and I didn't take it to heart, and I wish I did. He said, you should document your startup journey now and not wait for that product to come out. You should start taking pictures of your development, post it on Instagram, on social networking, and build a following even before you have a product. And he said, that's the way, you know, when you do release your product, you have this instant viral connection to people, and people will be behind you. And you know, I was just too busy, too lazy, like too caught up in other things. I wish I would have taken that to heart, and I wish I would have done that in my journey. So you know, for anybody that's doing a startup, even if you don't have a product yet, I would say start, you know, telling people about your idea, about your journey, your successes, your fails. I think that will emotionally connect people with your startup.
That was a great one.
Thanks.
Anything else, Stephen?
No, that's it.
That was great. Ido, you always been so generous with your time, with the cohorts, and you're a great peer to your cohorts.
Oh, my pleasure.
So just thank you. I actually feel like before the speed network, can you have like a little screenshot of the product?
Oh,
I'm using Michael
You have
Ryan
one
Norton.
handy. You could just
You got
hold
one
it.
handy? Well, maybe what you do is we'll unshare your slide.
Oh yeah, that's right. I didn't realize I was still sharing. Hang on a second.
No, I wanted to have your contact information out, but it's always a great. I remember when you brought it to the cohort, everyone was excited to see it.
Yeah. So I'm still working on it here. I don't know if you could see.
Yeah.
This is 3D printed. All the things in white are 3D printed, and it's Lego compatible. So you can use Legos to kind of glue the components together. I have a motor hooked up to this one. There's a 3D printed battery holder, and these are what do you call them? Wristbands that you use
those are nice
for tires.
Nice. Love it.
Yeah. So it's been a lot of fun, and it's something that I'm really passionate about.
No, you always been real passionate. Even the story, your founder story was great. I always remember was it with your daughter, or I just remember there was that founder story that was always really nice.
Oh yeah. It's just a matter of getting schools access to these kits. There's the ones that are out there are so expensive, and yeah, having them be able to have like tangible robotics kits is really will make a difference to a lot of schools, not only in the US, but a lot of developing countries where they can't afford any of those things.
And I think even more so these days when everyone's homeschooling and having
Right.
this access. So I think this is a good time. We'll keep following you. And I know I feel like this could be a little series. I think everyone loves you, Ido. You're always real generous. What we usually do, Ido, and you know about this, that we do this kind of speed networking so everyone can kind of talk a little bit about things. We can start that now, Stephen.
Sure.
And
yeah.
And then you usually do maybe a little wrap up before that, but I just want to thank Ido for coming.
Yeah, we'll do a little wrap up. I'll end the recording and we can start the speed networking. So yeah, for those of you tuning in on YouTube, whether it's recorded or whether it's live, feel free to like, comment, subscribe. This is kind of the same message from the beginning. But all the interactions we get with videos like this, whether it's a like, whether you're leaving your, an outstanding question for Ido or for our team, or just leaving your thoughts as a comment, helps these videos reach more people. And so each of those interactions might push this video out to somebody who really needs to hear this message or really needs to hear some, tidbit of advice that was shared today by Ido. So if you have a chance to do that, feel free to do so. But as always, thanks guys for tuning in for another episode of Tech School.